number D639564, Johnson versus Isaacs. Mr. Stoffel, looks like you are here on behalf of Mr. Johnson.
Yes, Jason Stoffel, 8898, on bottle capacity, appearing on behalf of Shaquan Johnson. He's in my office right now, present.
All right, thank you. Good morning, Ms. Isaacs.
Good morning.
The court set this status check to confirm that action was initiated in California. You're getting in on the tail end of this, Mr. Stoffel. This case, the court has determined, is a California case, and that the matter needs to proceed in the state of California. It's unfortunate because we had a senior judge sitting at the time that this case was first on the court's calendar who made a custodial order that I would not have made. But I also did not feel compelled to undo that, given that the children had already been uprooted at least once, and probably more than that, in the course of the recent history of these parties relocating to several different locations. So that's what the status check is on for. So I'm going to start with Ms. Isaacs and ask her if she has initiated a case in California regarding custody of the children.
Yes, I have.
And have you served that on Mr. Johnson?
Not as of yet. I initiated. Sorry, my words are getting slurred. I initiated everything via mail, and so I should be getting the case number and all the other documents to serve him soon. I did get a call from the court system out here stating that I did one document incorrectly and that I do need to go and refile that with them, and then I'll be able to serve Mr. Johnson.
Okay. So,
but I did inform that I had initiated custody out here.
Okay. So, Mr. Stoffel, you can address that. You can also, if you like, let the court know whether your client wants to pursue a status action down here. In other words, his action for separate maintenance or divorce. The status of their marriage, the court can address without addressing any of the custody issues, since that's sort of a race to the courthouse issue. So go ahead, Mr. Stoffel.
Well, real briefly, again, if there needs to be a UCCJA hearing, if there needs to be a California judge can initiate or request that. That's a fight for another day. It's not on calendar, but it's news to me. She filed anything, of course. She can probably serve her husband, in this case, the plaintiff, and we'll deal with it at that time. But I understand this court's not going to touch it. That is what it is, done. But there still should probably be a UCCJA hearing. But beyond that, everything's going fine here, but he's just saying, look, when am I getting divorced? And I'm looking at her answer and counterclaim. She put no community property, no community debts, no spousal. So I think we probably can bifurcate this under GOJAC today and do a status divorce, if nothing else, and then we kind of just wait to see if California does anything, or they ask for a UCJ hearing. They know the case number. They can deal with that. But right now, I don't know there's an objection on mom's behalf to say, let's get divorced. I don't think she wants to stay married much longer, but I think while we're here, we can probably swear the parties in and confirm, each get their own and be done with it. So this case was initially a separate maintenance complaint. It was subsequently amended for a complaint for divorce. So he is seeking divorce remedy. So perhaps we need to ask Mom, is she in agreement to a divorce today? And really, that's where we're at.
Well, I mean, I don't have any of the documents. I don't have an affidavit of resident witness. I don't have his affidavit. I understand that residency is something that we've been addressing through this process, but I can't just circumvent what is required to be filed. Are you opposed to Nevada granting a divorce that states there is no community property, no community debts? The custody issues won't be addressed within there. It will have to state that this court lacks subject matter jurisdiction to resolve any custody issues, but this way a divorce could be granted sooner rather than later. What are your thoughts, Ms. Isaacs?
So I actually, when I did the custody, I filed for the divorce as well in California. So me and Mr. Johnson had conversations in the past, and I don't think he's in agreement with them anymore. But I had let him know that I was going to file for a divorce and for custody in California. We had came up with a custody agreement, and I don't believe he wishes to stick with that anymore, but I did file the paperwork for the divorce here in California as well.
Okay, so under those circumstances, Mr. Stoffel, I can't tell her she's not allowed to pursue it there. She is. They have jurisdiction as well. And again, it's a race to the courthouse. So if he wants to submit summary disposition documents based on the fact that the parties' complaint and answer are in agreement with one another, then he can do that. So you understand, Ms. Isaacs, when I say race to the courthouse, it means both California and Nevada have the authority to address the status of the parties' marriage. So I can divorce the two of you if you're in agreement. There's no community property, community debts, no spousal support should be paid. Then I can also adjudicate that or resolve that here in Nevada. If you want to pursue it in California, I'm not going to stop you. Whichever one of you gets the matter addressed by the court first, resolved by the court first, is where the divorce will be granted. Okay.
Okay.
So
Do we know if she's alleging?
Go ahead.
Sorry, is she alleging any assets or debts? Because it's one and the same. A divorce here is the same as a divorce there. But if he's not living in California ever, or at least quite some time, I don't know if they even have jurisdiction over him, personal jurisdiction. But it might be potato. If everyone wants a divorce, what are we waiting for? I guess. But again, when you fill out a form in California, they probably ask your marital status. So of course you put married, and then it's logical then just to say, well, I want a divorce too. So. She doesn't have to make a decision on the divorce like today, I suppose, but I just don't know if there's a reason to hold it up anymore. Because the court, you're right, could grant the divorce if there are no asset debts to work out. We can subsequent the file for a resident witness affidavit, and you can swear him in to get his statement as to incompatibility and no chance of reconciliation. We can go that route, but I'll leave it to the court.
If she's going to stipulate to that, I'd be happy to do that today, but I don't hear her stipulating to that. And so you can proceed on the pleadings, Mr. Stoffel. I'm not denying the relief that your client is requesting,
Right.
and I'm not denying that he's entitled to it, but she's entitled to process as well. And I do believe that there was a time that they all lived in Sacramento, and that Sacramento or California does have personal jurisdiction over him. I'm confident California has personal jurisdiction over him. So
We
anyway,
disagree,
you
but-
can agree to do that today, Miss Isaacs, and I'll proceed with granting an uncontested divorce, meaning you two are in agreement. Do you agree that there's no assets and debts?
There are no assets and or debts.
And do you
Joint.
agree that there's no spousal support to be paid?
No, I don't agree with that.
Okay. So there you go, Mr. Stoffel. And I don't know off the top of my head what her response to the complaint was, whether it included that there was a potential for spousal support or that she was seeking it, but
She waived it.
unfortunately, it's not going to go
Okay.
as quickly maybe as your client would like. Okay, so I'm not in a position to dismiss the case. If he wants to pursue a divorce here, he can do that, but he's going to have to follow the process for getting that done.
Do we want to make the comment?
Go ahead.
Sorry. You want to make the comment that the door is open if that's what is to be done. It's not going to prejudice her in custody matters here or California. If she says, you know what, change my mind, I want a divorce, what do I do? Our office or someone here will draft the decree of divorce as just status only, basically, and then say that at this time custody does not appear ripe for Nevada consideration. And then if California says otherwise, we'll deal with it. But we've got that hurdle to go with. But as far as further proceedings here, we're just on hold, or what are we doing? Because there are simultaneous proceedings.
There are simultaneous proceedings, and again, I appreciate that offer. I hope you understand, Miss Isaacs. He's offering that if you change your mind and you do want to help facilitate the finalization of a divorce here, you can reach out to him. In the meantime, I can't and won't stop Mr. Johnson from pursuing the divorce. I'll have my department send out notification of a case management conference, so we'll get those proceedings on calendar, Mr. Stoffel. In the interim, if your client does want to file his affidavit of residency and an affidavit of resident witness, then the court will have on file what's needed to finalize the matter if that's what it comes down to. Okay.
Okay, sure.
Okay.
Can I say something real quick to Mr. Stoffel? Mr. Stoffel, I received a notice of service this morning.
Yes.
And on that notice of service, both of my email addresses are incorrect. So on the 4th, I didn't receive anything from you when you had sent it out. One of my email addresses is Robin.Isaacs, and you had put 3 A's instead of 2. And the other one is Robin_Johnson146 @yahoo.com.
Are you
Okay.
registered for e-service?
She is registered. That's what we got that, but somehow she still got it. So
Okay.
okay. Okay.
No, I got the notification from the court.
Okay.
So, yeah. But thank you. But so, like, if anything in the future, if you have anything that she needs to send me or anything like that, just for future reference.
All right. Can you spell it? Just so I have my records, you rattled off, and I wasn't sure what you want me to do. What is the best document for any e-service that you have? Or email?
The email is Robin, ROBIN, Isaacs, ISAACS 93 @yahoo.com.
Got it. Okay. I appreciate that.
All right. Thank you so much. Appreciate it.
Okay.
Okay.
We'll send out a notice of case management conference. So
Okay.
there will continue to be proceedings potentially in this department, in this court, again, related to the divorce only. Okay, Ms. Isaacs?
Gotcha.
Thank you.
He'll probably re-retain me for future work. I know today, unbundle through today, so if you want to do a courtesy notice, but we will file withdraw this as a courtesy, but we'll go from there. And I can always look online. My guy will get service, and he can say, hey, I need you in a couple months or what have you. We'll deal with that. And then we wait, I guess. We'll see what we're doing.
Okay. Appreciate it. Thank you all.
Okay. And then do you need an order for today, Judge? I can draft it.
I do not.
Okay. Minutes can suffice?
Minutes will suffice. I'm not really making any substantive orders.
Okay.
We're talking about how this is going to proceed through the court system. And again, you'll be receiving a notice of case management conference. So we can address any other specifics at the next proceeding if necessary.
Okay. Got it, Judge.
Okay. Thank you.
All right. Thank you.
No.